Hello and welcome to the Minimum Competence episode for Thursday, February 13th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover a lawsuit over Trump's firing of a federal official, a Massachusetts court's move to curb judge shopping and challenges to administration policies, and the rising environmental cost of Bitcoin. Let's remember, the key is not to prioritize what's on your schedule, but to schedule your priorities and read today's legal news. On this day in legal history, February 13th, 1801, the U.S. Congress passed the Judiciary Act of 1801, a controversial law that reshaped the federal court system. Enacted in the final days of John Adams' presidency, the act reduced the number of Supreme Court justices from 6 to 5 and created 16 new federal judgeships. It also eliminated the justices' duty to ride circuit by establishing separate circuit courts with their own judges. The law expanded federal jurisdiction, making it easier for creditors to bring cases in federal courts and granting them broader enforcement powers. Federalists, who controlled Congress at the time, saw this as a way to strengthen the judiciary before Democratic-Republican Thomas Jefferson took office. Adams quickly filled the newly created judgeships with Federalist allies, leading to accusations of court packing and what became known as the Midnight Judges scandal. Jefferson and his party viewed the act as an illegitimate attempt to entrench Federalist power in the judiciary. In 1802, the newly elected Republican majority Congress repealed the act, effectively undoing the judicial restructuring. This marked one of the first major political battles over the structure and independence of the federal courts. It also set the stage for future conflicts over judicial appointments and reforms. The Judiciary Act of 1801 played a key role in shaping the relationship between the executive, legislative, and judicial branches. It demonstrated how shifts in political power could influence the courts and foreshadowed later debates over judicial authority. The controversy surrounding the act also contributed to the landmark 1803 case Marbury v. Madison, in which Chief Justice John Marshall established the principle of judicial review. This episode remains a crucial moment in American legal history, illustrating the judiciary's evolving role in government. Kathy Harris, a Democratic appointee to the Merit Systems Protection Board, or MSPB, has sued President Trump over her removal from office, arguing that the firing was unlawful. Trump also dismissed Ray Lamone, the board's vice chair, and replaced Harris with Republican Henry Kerner as acting chair. The MSPB, an independent agency, hears appeals from federal workers who are fired or disciplined, a role that could become crucial as Trump pushes to shrink the federal workforce. Harris argues that her removal violates legal protections for independent agency officials, citing the Supreme Court's 1935 ruling in Humphrey's Executor v. United States, which limits a president's ability to fire certain officials without cause. Trump's decision to involve Elon Musk's Department of Government Efficiency in identifying federal job cuts adds urgency to the case. The lawsuit is part of a broader legal battle as Gwen Wilcox, another Democratic official fired from the National Labor Relations Board, has filed a similar claim. A hearing is set for today before U.S. District Judge Rudolph Contreras, where Harris is seeking a temporary restraining order to regain her position. The White House defends Trump's authority to remove officials, setting up a potential Supreme Court fight over presidential power and the future of independent agencies. A federal court in Massachusetts has implemented new rules to curb judge shopping as lawsuits against President Trump's policies continue to mount. Chief U.S. District Judge F. Dennis Saylor issued an order requiring the cases seeking to block federal laws or policies be randomly assigned across the entire district, preventing litigants from filing in single-judge courthouses in Springfield and Worcester to secure favorable rulings. This move aligns with a 2024 U.S. Judicial Conference policy aimed at discouraging strategic case filings, a practice criticized when conservatives challenged Democratic policies in Texas courts with Republican-appointed judges. Massachusetts, a frequent battleground for legal challenges to Trump's agenda, has seen its judges temporarily block his administration's efforts on government employee buyouts, research funding cuts, and prison transfers for transgender individuals. With most of Massachusetts' federal judges appointed by Democratic presidents, the concern was that plaintiffs could manipulate the system by filing in small courthouses with sympathetic judges. While some federal districts have adopted similar rules, others, including in Texas, have resisted. The issue remains contentious, with Senate Republicans and some conservative judges opposing the policy as unnecessary judicial interference. And in a piece I wrote for Forbes this week, I wrote about the explosive growth of Bitcoin and how it has brought with it significant environmental tolls, with mining now consuming up to 2.6% of U.S. electricity and producing emissions comparable to entire nations. Bitcoin's proof-of-work system relies on energy-intensive mining, straining electrical grids, driving up prices, and using vast amounts of water for cooling. Despite these concerns, states like Texas have embraced miners, offering low-cost energy and deregulated markets. The Trump administration's January 2025 executive order on digital assets calls for, quote, responsible growth, but it remains unclear whether sustainability will be a priority. The order could enable states to integrate eco-friendly policies, such as tax incentives for green mining or licensing tied to renewable energy use. Addressing crypto's environmental impact could also be framed as an issue of energy independence and national security, potentially making it more politically viable. A carbon tax on proof-of-work mining could be one way to push the industry toward cleaner energy, though it will be a tough sell under a deregulatory GOP administration. However, some conservatives, including economist Art Laffer, have supported carbon taxation in the past. If Bitcoin miners want to avoid future crackdowns, they may need to adopt sustainability measures before stricter policies are imposed. Whether the executive order leads to real change remains uncertain, but the environmental costs of crypto mining are only growing. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, it's not enough to be busy, so are the ants. The question is, what are we busy about?